The Constitutional Court has given Parliament, the President, the IEC and the Department of Home Affairs, who are respondents in the Electoral Act matter, until the 8th of August to make their submissions regarding an application by the Independent Candidates Association. Now, almost 2 months ago, the association approached the Constitutional Court seeking direct access on an urgent basis to challenge what they find to be the flaws in the newly amended Electoral Act. Now, the Act was passed into law in February this year, but civil society organizations and other interest groups are arguing that the Act in its current form is still biased against independent candidates from standing for public office in the country. Dr. Michael Louis is the chairman of the Independent Candidates Association and also an applicant to the Constitutional Court, and he joins us now to discuss this matter further. Dr. Louis, good to have you with us once more here on Morning Live. Welcome.
No, good morning to you and to the listeners, or to the viewers.
Indeed. So perhaps just to make sure that we're all on the same page, let's just give a little bit of background very succinctly.
Well, look, I mean, the big thing is that, as we know, the New Nation movement was in front of the Concourt. They ruled that the Electoral Act that we currently have was unconstitutional. They gave Parliament 2 years to redraft a new Electoral Act, which Parliament did. And unfortunately, we believe in a participatory democracy. Civil society was very much involved in the 2 years in drafting and submitting to Parliament all our complaints and what we believed was not constitutional. And I'm really saddened to say that we don't believe that Parliament heard our voices. They actually drafted a bill that was unconstitutional. It went to the president, and in February this year, the president signed it into law. And we still believe that the Electoral Act is unconstitutional, and that's why we challenged it, as you said, in February.
So let's talk about what makes it still unconstitutional in its current form.
Well, there's numerous things, but I think the main thing is that the whole bill is written that independent candidates are not on the same playing field as political parties. The whole act is written to benefit political parties. But what the Independent Candidates Association is doing is we're focusing only on one element that we believe is unconstitutional, and that is that when the elections are complied with and finished in the 2024 elections, when they do the seat allocations, as we know, there's 400 members of National Parliament. So what has happened is when they do the seat allocations, what we call the quota, in the past and currently, political parties to qualify only need 43,000 votes to get a seat in Parliament. The bill is written, and now the Act is written, so that for independent candidates to qualify, because it's now regions, will have to get between 77,000 votes and 93,000 votes, nearly double that of political parties. And it is because independent candidates don't qualify for compensatory seats. So I'm sure all the viewers also won't be satisfied that if they have to stand for elections and they are independent candidates, that they have to get double political parties to actually feature in Parliament. And that's why, as an association, we're really struggling to encourage independents to stand, because why must they stand? They're going to spend more money. They're on their own. They must do their own branding, and then they still must get double the votes of a political party.
So, Dr. Louis, as it stands, what are the practical implications if the country goes to next year's general election with the Act in its current form?
Well, look, I mean, the big thing is that's why we believe that civil society must always be seen as a constructive force. And we can't allow that we go into an election of 2024, and if either political party or an independent candidate believes that the Act is unconstitutional, to challenge it post-election. So that's why we are really elated that the Constitutional Court is giving us this opportunity to ventilate with government all the unconstitutional issues, so that we can, before the time that the Constitutional Court can adjudicate the new Electoral Act and say that it is constitutional, that we know it's fair and free, that everybody is equal in front of the law. So we elated because now we've got till the 8th of August for the responding president, the speaker, the Minister of Home Affairs to respond to our application. And then we go and ventilate it, and we're really very elated about it.
So with that said, as you say, the respondents have been given until the 8th of August. What would you like to do, rather the Concourt to do with this newly passed law? Because it's clear that, you know, from what has been said, from the way things have moved, that we probably are not going to see any more changes going back to Parliament. And then I say this hypothetically, but, you know, what would you like to see the Constitutional Court do, Dr. Louis?
Well, we know that the Constitutional Court is very respective of the three arms of government, and they don't want to get involved in what Parliament must do. And that's why the relief that we are asking is that they suspend this Act for a period of 36 months, because we know that the new Act also makes provision for an electoral panel. And all we're asking is that they do a striking down or a writing in where they're saying, we're going to suspend this Act for 3 years so that Parliament can redraft this Electoral Act and do it properly. But that's not the only relief that we're looking for. We believe that if independent candidates are given an opportunity to take part in an election where there's 350 seats allocated for direct elections and only 50 for proportional representation, that will then make independent candidates and political parties each get a quota threshold of around about 45,000 seats. And the nice thing about it is that we had actuaries that have written their reports and submitted it to court, that if independent candidates and political parties take part in a system where it's 350 for direct elections and 50 compensatory, that we believe it will be fair and free. And it's an easy adjustment for the Concourt to adjudicate and to make such a judge.
So with things as they stand, Dr. Louis, and looking at the time that we have until the next general election next year, the time that the court challenge may take, will this be resolved by the time we go to those elections?
Well, look, the nice thing about it is that this is post-election. So that's why I said, you know, we want it to see a constructive force, that we don't want to delay it. So that's why I really am asking, not asking, but I mean, I really believe that the President and the Minister of Home Affairs have still got an opportunity to say that they don't believe that this application should get direct access. And that's why we believe that that will postpone the elections. So we're asking them to comply, to support a direct access application, and that we go to court, ventilate it, and then that won't postpone elections, because this is post-election. So this is only about counting of the votes after the elections have taken place and not pre-election. So I still believe that this won't be a postponement or cause any postponement to the election.
Well, you're very hopeful, Dr. Louis, and is going to see how we can't wait to see how all of this plays out. Given how things have gone, I can't wait to see where this finally ends up. But thanks so much for bringing us up to speed. That's Dr. Michael Louis, Chairman of the Independent Candidates Association and an applicant to the Constitutional Court. The organization has approached the Concourt for direct access, hoping to make submissions on their concerns against the newly passed Electoral Act.